I'm not threatening you. Say one more word and that's 30 days. 30 days. Court does call the case People versus Radiance Evans.
Good morning. This case is proving to be challenging already. And Ms. Evans will not meet with me. Although in the conversations that I have been able to have with her, she has her PPO violation before Judge Slay. It is my understanding from when I have been able to speak with her that she would like to schedule this for a preliminary examination and proceed in all things available to her. I don't know that if I refer to her competency that she's going to be found not competent based on what I can ascertain of her understanding of all the proceedings, who I am, what she wants to do in terms of her defense. So I would ask that the court set this for a preliminary examination. And then I'm curious to see how the court will respond to my request.
My understanding is she does not wish to come to this hearing. So I'm not going to set it for a further proceeding until she decides she wishes to participate.
Okay.
So I will adjourn this out. Would you like 1 or 2 weeks?
Let's just do 2 weeks.
2 weeks. So I'll adjourn this out June 6th, 2024, 9 a.m.
Thank you, Judge.
Thank you. Bond continued. Court does call the case People versus Casey Adkin. So she has another PCC before me.
That's my understanding, Courtney.
I'll adjourn this then out 1 week, May 30th, 2024. 9 a.m. Bye.
Thank you, Mr. Canal.
Really? She just leaves before I'm done?
I think she's got the date. I thought she thought it was done.
And no, go. Just go. Bound continue. Just start walking. Really?
All right, Judge. Thank you.
No, it's okay. Next one of your clients that does that, I'm snatching you up and sending you back. Court calls the case People versus Daniel Gates.
I ask the court to please set this for exam. Your Honor, discovery is late at this time.
Miss Hughes, sister.
Thank you, Your Honor. I downloaded a spreadsheet of defendants' jail calls and sent them to defense counsel, and then I downloaded the relevant jails and sent them to him so we get an opportunity to listen to them. I am requesting that the defendant's jail phone privileges be revoked. Since his arraignment, the defendant has contacted the victim. He actually had another defendant who's present today, we'll hear about him shortly, call the victim of this case and ask her for a different phone number. She provided that different phone number to other defendants that she otherwise doesn't know. And when I searched that different phone number in the jail call system, the only person to have ever called that number is Mr. Gates after that. So I'm requesting that his phone privileges be revoked. And I provided the jail calls to the defense.
Defendant's bond will continue, however, defendant's phone privileges are hereby ordered revoked.
Great Memorial Day weekend. Your staff, Your Honor.
Take care. Court calls the case People versus Rajad. Is it Ajafrasik?
Got it, Judge.
Got it. Did I?
You got it.
I knew it. I knew I had it. I knew okay.
Good morning, Your Honor.
Ready, Judge. Torshio Feaster, Assistant Public Defender on behalf of Mr.
Court does call the case People versus Cody Jolly. Your name, sir?
Cody Lee Jolly.
All right. And we have your competency report back. Have you had an opportunity to review that, sir?
I have.
Pardon?
I have.
All right. Is there any other additional evidence you want to give the court?
Not at this time.
None from the people, Your Honor. We would stipulate to the report authored by Graham Parker dated May 7th, 2024, and ask that the court make its finding based on the.
Based upon a review of that report and the only evidence before the court would find that the defendant is competent to stand trial and that defendant understands the nature and objects of the proceedings against him and can rationally assist in his defense. And so the defendant is deemed competent. I'd ask the people to prepare an order if you could
Yes, sir.
in this instance. Mr. Jolly, do you still wish to continue to represent yourself, sir, or do you wish to have the assistance of an attorney?
Continue to represent.
And sir, I do also have to advise you that you are before the court on 2 charges. It's 2 charges. Yes. 2 charges of criminal sexual conduct in the 4th degree. You understand that, sir?
I do understand.
And that these are alleged to have occurred on January 27, 2024. You understand that?
I do understand.
And the court also does have to advise you that these are high court misdemeanors. They are punishable by up to 2 years incarceration and or a $500 fine plus court costs. Mandatory HIV and STD testing and DNA would be taken upon your arrest and should have been taken. You understand that, sir?
I do understand.
All right. So, sir, I will formally ask you, do you still wish to proceed without counsel?
Yes, I do.
All right. What do you wish the court to now set this for, sir?
The last that I was aware of was the preliminary exam that we were doing. I'm trying to move forward as quick as possible, so I'd ask you if that's where we start, that's okay. If we move
You
forward,
wish to set for a preliminary examination?
if that's the furthest along I can get, then yes.
Well, that's the next step.
Okay, then yes. That's
All right. So you want to have a preliminary examination in this matter, or you want to proceed to circuit court? There are a number of options that you would have.
okay. Yeah, if we can proceed right to the circuit court, that would be okay.
Okay. All right. But you understand that there would not be a hearing, the preliminary examination, which the court would.
I choose to represent myself. I was aware of the help and was thankful for the help the other day. If you recommend that I talk with somebody as I leave here.
Well, I'm not going to recommend you do anything. I'm a little bit concerned because when I ask you questions, I don't think you know what you're doing. I don't think you know what you're doing procedurally. And that causes me a bit of a concern. You want to get to, as I told you the last time you were here, you want to get to a certain point. You're not sure how
Let's
to
go back
get
to the
there.
preliminary exam we can
You
schedule.
want a preliminary examination?
That'll work. Yep, yes, I will.
All right. If you want a preliminary examination, you intend to represent yourself. Is that correct, sir?
Correct.
Do you have all of the discovery, sir?
I filed for it. I'm gonna have to refile now that I'm competent, but I don't. Not when I'm in my possession because I was incarcerated.
All the discovery has not been provided. You don't have it.
It was emailed to me, but I'm incarcerated now, so I don't have it now.
So it was emailed to you when you were out.
Correct.
Try to make sure that whatever discovery is, it be provided to the jail so that they can get it to this defendant.
I can print another copy of the report,
Okay.
not today. The printer in our office is broken, but there was a media notice that was body cam that was given to him in court at one of the last dates.
Okay. Remember that, sir?
I do remember the disc. Yeah, I didn't. Yeah.
Okay.
So he has the disc.
He has the disc. He just
Another copy of
get the paper report and we'll get that to you. Okay. Would the people have their witnesses available the 4th or you need more time? All right. Preliminary examination in person will be set June 11th, 2024, 9 a.m. That's before me. Bond will continue. Okay. All right. Thank you, Mr. Jarley. Court does call the case of the People versus Bruce Jones. Preliminary examination will be set in person June 4th, 2024, 9 a.m. That is before Judge Perry. Bond will continue.
Need to address his other tampering from the last date. I'll go with the phone privileges first. At the last hearing, I believe it was Ms. Rosso requested that his phone privileges be revoked. The defendant requested a hearing on that. After Your Honor then revoked his phone privileges, When the defendant went back to the jail that very same day after leaving your courtroom at 10:50 a.m., he got on the phone and called the victim and advised the victim that you had revoked his phone privileges, and then instructed the victim to download an app called Text Now. And he said, if they're going to take my phone privileges, I'm going to still call you, but another way. And that was after Your Honor revoked his phone privileges. Since then, as far as I can see, his phone privileges have been revoked. But he did manage to get to the phone and make that call after the last hearing of the court today. And then we still have the tether tampering, which is where Community Corrections received the notice that he was cutting his tether. They reached out to him. They asked him to take a picture of his tether to show them that he wasn't cutting it. He refused to do that, and then they see based on his location services that he was then leaving the area that he was in. He was arrested. The tether has a clear cut mark on it, and he told Community Corrections that his dog was chewing on it. So at this point, I'm requesting that Your Honor continue to deny his bond, which was denied after the tether tampering situation, and I'm asking that Your Honor continue the revocation of phone privileges.
The client wants to focus more on the preliminary exam and deal with the case at hand, Judge.
He's waiving the hearing on the phone issue.
Yes, Your Honor.
All right. And the court will order that his phone privileges are revoked as they previously had. And so his bond will continue in all other aspects as revoked.
Thank you, Your Honor.
People versus Christopher Farner. What are we doing?
Your Honor, at this time, we wish to set this for exam.
Preliminary examination in person will be set June 4th, 2024, 9 a.m. before Judge Washington.
I have kind of two options to my request, please. One is I'm requesting that his original bond be ordered at $200,000 cash. And I think you have questions. That is the request that we made at the time we charged it, and my position is that his bond should have been set at based on the facts of this case. In the alternative, I'm asking that Your Honor revoke the defendant's bond and remand him today for his bond violations. So I'll start with the bond violations, perhaps. After the defendant was arrested and in custody, and after he was released, he made 86 attempted calls to the victim, and 23 of those calls were completed. I had the opportunity to download a PDF and send that to defense counsel, as well as download the 23 completed calls. I did also accidentally download some of the incompleted calls and sent those her way as well. But she's had access to them since yesterday, which is when I discovered them. I have not had the opportunity to listen to the content of all of the 23 completed calls. Of the calls that I was able to listen to, I was able to listen to the defendant talking to the victim about arranging his bond posted, arranging his pickup at a gas station near the jail, the two of them talking about how to get the no contact order dropped, about how they can have contact with each other once. So I'm requesting that his bond be revoked and that he not be permitted phone privileges in the jail for those violations. In regard to, and I should also note in terms of the jail phone calls, this is the defendant from Mr. Gates' case earlier when I mentioned that he had another defendant from the jail call and asked his victim for another phone call.
The other number?
Yes, this is Mr. Fickner is the person that participated in that, and he's the one that called her victim. Excuse me, Mr. Gates' victim. So in regard,
So he called the victim in the other case to get a new phone number so that that defendant could contact that victim.
correct. Thank you, Your Honor. In regard to the facts of this case, the defendant, and I'll kind of jump to the end and then go back through it. The defendant at the end of this admits to the police that he was intoxicated while driving the vehicle. While he was driving the vehicle, there was minor children in the car, one of which was an 8-year-old child who told the police that while she was in the car, she heard the defendant saying that he was going to crash the car. She experienced that he was driving really fast, and then when they got home, she watched as he was choking her mom. The victim is that child's mom, who reported to the police that in the car, the defendant decided to begin an argument with her, calling her a psychopath, saying to him that she could not take his guns away from him, that he hit her in the head while he was driving, and actually while he was still driving the vehicle, began to strangle her. The victim reported separately from the interview with the child, reported that the defendant told her while he was driving the car that he was going to crash the car, kill them all, and that it would be her fault. He said that with children in the car, and that the 8-year-old subsequently corroborating that. As I mentioned earlier, he had consumed alcohol, and he later admitted to the police that he was intoxicated at the time of driving that vehicle. In the vehicle, put both of his hands around the victim's neck and strangled her. She couldn't breathe. At a stop sign, the victim tried to get out of the car to flee, but the defendant sped off. Once they were home, inside the home, both of her parents were present, and her parents were interviewed separately. The victim told the police that the defendant choked her and threw her to the ground. The victim's father, who was present, said that he walked in and he saw the defendant with the victim in a chokehold, that he said, "What the F," except he actually swore, "Are you doing?" And the defendant immediately released her, throwing her to the ground. The mom also was interviewed separately. She said that she saw the victim push the defendant, and that the defendant then put his hand on the victim's throat and began pushing her by her neck, and that the mom then left the room and did not see what else happened. The police observed redness on the victim's neck, a V-shape, they put in the report as a blood blister near her trachea, and those are the injuries they observed of her. So just based on the facts alone of this case, I am reviewing my office's response to that would have been the appropriate bond to set at the time. However, if your honor is inclined to, frankly, I'm asking that you just revoke bond completely, set him a bond, remand him for these jail calls and contact he's had with the victim after the agreement, and order that he not be permitted to use the phones in the jail. Thank you, Your Honor.
A lot or all?
Well, some of the identifying information would be correct in the report, but the allegations that would be criminal, my client denies. As to the jail phone calls, that is correct. Ms. Hughes did provide me with both the log and a folder with the calls in them yesterday afternoon. I have had the opportunity to review the log. However, I have not reviewed the substance of the calls in their entirety. I would acknowledge that some of the calls were made to the complaint witness's number and arraignment. However, to my understanding, there are no allegations of any other bond violations, either contact or otherwise, since my client's released from the Washtenaw County Jail.
What about his participation to facilitate another individual violating their bond condition?
The first I'm hearing of that is today, Your Honor. So I can't speak as to that whatsoever. I am asking the court to keep the bond set as where it is. Mr. Fainer has been out for, I believe, how long have you been out since posting your bond?
Last week, Thursday.
Last week, Thursday, so exactly 1 week, Your Honor. To my understanding, in that week, he has not had contact with the complaining witness nor violated his bond in any other way. We are asking for it to stay as is so he continues showing up to court, and he has been very active in the defense for this case. He is a foreman for a construction company and does have full-time work providing for his 5 young children. We are asking the court to keep bond where it is at this time.
Well, I don't know why the bond was set on those facts. Is he on a tether?
Yes, Your Honor.
Given the facts of this case, or at least as they're related to the court, I believe that the bond as set is an abuse of discretion. Everything that's mentioned is high lethality. The alleged victim in this case ended up at least going to the hospital to tend to wounds that she is alleging were caused by the defendant. Moreover, then that after all of this occurs, and what causes the court a great concern is to the defendant's conduct is that there are these contacts that aren't supposed to be contacts while he's in the jail, that then also then while he's in the jail, and I don't have any reason to dispute it because I had to revoke that other individual's own privileges. He facilitates, not only does he violate a condition of his bond, he then facilitates another inmate to violate the bond in the case or in the other case. Not going to happen. It's just simple. I think the bond initially was set wrong. His behavior since then would lead this court to believe that the defendant cannot conduct himself reasonably, would also then pose a danger not only to the community, but to this particular victim and to the community as a whole. Defendant's bond, and he hasn't complied with the bond as we've said it, Mr. Allen. Defendant's bond is hereby ordered revoked. His phone privileges are also ordered revoked. Defendant is remanded. Court calls case People versus Victor Hayes.
Thanks, Your Honor. This is going to be a waiver and a bond violation.
Yeah, it may not be a waiver. He's blowing numbers. Why?
Oh, Your Honor, this was
Mr. Allen.
This was an honest mistake on behalf of Mr. Hayes. He had company over on May 8th. He blew a .033 on his SoberLink. He's been on a SoberLink since November. And when he was having dinner, the company that he had with him, his friends and family, they had non-alcoholic wine. And Mr. Hayes was unaware that non-alcoholic wine actually can contain some to little bits of alcohol. So Mr. Hayes just wants this court.
You're going to tell me you got to a .03 on non-alcoholic wine? Is that? No, I mean, if that's what you're telling me, go ahead. I just want to make sure I'm hearing what you're telling me.
Your Honor, I spoke with Mr. Hayes about this, and the only explanation to this violation was what I just stated for the non-alcoholic wine at dinner. And he wants this court to know that this was an honest mistake. He understands that he needs to do his due diligence and make sure that he's not around any alcohol whatsoever. And he would just like you to know that, he's sincerely apologetic, and he's asking this court if it would allow him just to give him a chance to remain out of custody, continue to test while he's doing.
Then tell me the truth.
Judge Simpson, can I address the court, please?
If you want.
I've been testing for a while, and this all started in 2022 when I took it upon myself to this, and I had company over, and we had what I assumed was a non-alcoholic wine.
Hold on. You assumed it to be, or it was?
I assumed it to be. So I take.
Well, hold it. There's a big difference. Huge difference.
Well, only what I can say is that she said, "Oh, this is non-alcoholic, so I'm not supposed to drink." She said, "Well, this is not non-alcohol." So when I got the call from Mr. Wells and he said that I have blue numbers, I was shocked. It really didn't taste like alcohol, but I take full responsibility. I apologize to the courts. I'm trying to do my best to comply with what the courts want me to do. I've been 0-0-0 quite some time.
When you test.
Yes, I see Mr. Allen is behind me, so I know what that means. So I mean, I got a lot of responsibility, and I apologize to the